Any mention?
Well, it's item number 17 of the hearing list, but I'm praying for 2 weeks' time.
Criminal appeal?
Criminal appeal, madam.
3 weeks.
Obliged.
Please, Your Lordship. Lordship, I beg to mention item number 16. It is item 16, Lordship. Lordship, if the matter may come up after 2 weeks, Lordship, preferably on the first week of April, at Your Lordship's convenience.
16.
16.
2 weeks.
Deeply obliged.
Item number 1.
May it please Your Lordship. Your Lordship, in this matter, I am to file my rejoinder to the affidavits and oppositions filed by the respondent district council as well as the private respondents. Your Lordship, as I'm not ready with the same, I'm humbly praying for further 2 weeks' time.
Mr.
I'm sorry.
The petitioner has once again sought for time to file the rejoinder affidavit to the affidavit in opposition filed by the respondents, since the same could not be done so today. Pray aloud. This is matter up to 2 weeks.
Furthermore, Your Lordship, one more submission. In my writ petition, there has been a bona fide mistake on my end, whereas there is one page which is annexed as annexure number 26 in page number 194. Your Lordship, in this annexure, I had only placed the translated copy of the document, and I had failed to produce the original copy which was relied upon to translate the same. In this regard, Your Lordship, I humbly crave leave before this honorable court to allow me to insert the relevant pages.
You are also relying on this.
Yes, Your Lordship, I'm relying.
This is a translated copy. You can, at the time of hearing, you can always produce it.
Yes, Your Lordship.
If there is no objection from the respondent.
I'm appearing for respondent number 123, Your Lordship. We have already received this, no objection.
Instead of complicating matter for you to file an affidavit to bring this on record, incorporate it, amend the petition.
Yes, Your Lordship.
If it is not so material, in as much as the translated copy is already there.
Yes, Your Lordship, it is a part of the record.
If there is no objection by the respondent, at the time of hearing, you can introduce the same.
Very well, Your Lordship. Highly obliged, Your Lordship.
Item 3.
Because what happened, Your Lordship, in that writ petition, there is a relief claim for setting aside the order dated 31/3/2018 and order dated 11/4/2018 and 27/4/2018, Your Lordship. So, Lordship, then I'll address Your Lordship minus this writ petition 479/2018, Your Lordship. That I'll address separately, Your Lordship.
So it will be a common argument as far
It
as
will be
the
a
others are concerned.
common argument for all, for writ petition 470, Your Lordship, 471, then 481, 480 and 481, Your Lordship.
Yes, yes.
If Lordship kindly have writ petition number 470.
Yes.
Lordship kindly have their prayer, that is at page 11, Your Lordship.
Yes.
Lordship, this is for to strictly act upon the suggestion, recommendation, and of the committee report dated so and so, and direct the respondent to pay the area salary to the petitioner with effect from November 2016 and January 2018 till date, Your Lordship. Lordship, to that, Your Lordship, we have filed the affidavit, and if Lordship kindly have paragraph 5 of the affidavit. Paragraph 5, Your Lordship.
This is affidavit on behalf of
This is 123, Your Lordship.
123.
This is by the state, Your Lordship. Lordship, the salary for the month of November 2013 to January 2014 and for the year 2016, this was drawn by the respondent number 4 and 5, that is the school managing committee, Your Lordship.
Yes.
And then, Lordship, the amount had been
You're referring to which para?
paragraph 5 at page 2, Your Lordship.
Paragraph 5.
Lordship, yes.
Yes.
And then, Lordship, kindly have paragraph 15.
What
Your
does
Lordship.
paragraph 5 says?
Paragraph 5, Your Lordship, we say that the salary for the month of November 2013 to January 2014 and for the year 2016 was withdrawn by the respondent number 4 and 5, that is the school managing committee, Your Lordship.
Yes.
And Lordship, kindly have also paragraph 15 at page 4.
Yes.
Lordship, kindly see, for that period, Your Lordship, for that period, we have released, the state has released an amount of 13,96,000 to the school managing committee, that is the principal principal of that particular school, Your Lordship, and an amount of 3,12,000 had been refunded, Your Lordship. For that particular period, Your Lordship. Then subsequently, Your Lordship, there was an order passed by Your Lordship to, that is the order 19/2/2026, Your Lordship, asking the state regarding the status of the payment of the salary. Lordship, that we have filed, Your Lordship, that I'll come later on, Your Lordship. Then Lordship, kindly have a writ petition number 471/2018, that is Sufiqul Islam. Here also, if Lordship kindly have page 11.
Just a moment. Silang tukar affidavit.
480. 481 take out, no? Lordship kindly have
11.
page 11, your Lordship. This is for the same period, and Lordship, strictly the same, your Lordship, as in writ petition number 470, your Lordship. The relief claim.
Yes.
And Lordship, in that also we have, if Lordship kindly have paragraph 6, your Lordship.
6 of
6 of the affidavit, your Lordship. We have filed the affidavit also, your Lordship, in that petition. This is the enhanced salary, your Lordship.
just a moment.
Lordship.
This is affidavit dated 29 July.
Lordship.
Affidavit dated 29 July.
24 July 2019, your Lordship. Huh? July 2019, your Lordship, yes.
Yes.
Before, your Lordship, the salary is only 12,000. Then the state has enhanced to 24,000, your Lordship.
Paragraph 6.
Lordship, yes. Then Lordship kindly have a paragraph 12 at page 4. This is the same statement, your Lordship, as in the earlier petition, your Lordship. Really, the state has released 13,96,000, your Lordship,
Yes.
to the principal. That is the respondent number 4 and 5, your Lordship. Then 3,12,000 has been refunded, your Lordship.
Yes.
Then Lordship kindly have writ petition number 480 2018. Abdul Kalam Assam.
For 80.
480, Lordship, yes. Lordship kindly have page 12. Lordship has gotten.
Yes.
For it, at page 12, your Lordship. These are the same relief claim, your Lordship.
Yes.
And Lordship kindly have also the affidavit filed by the state, by the state. Lordship, it is a reiteration of the earlier of the statement made in the affidavit filed in the other writ petition. Here, your Lordship will kindly come at page 3 at paragraph 10. Paragraph 10, your Lordship.
Just one.
This is the enhancement of the salary of the teacher from 12,000 to 24,000 with effect from 2016, your Lordship.
Yes.
Then Lordship kindly have paragraph 18 and 19 of the of the affidavit, Your Lordship. 13,96,000, Your Lordship. That is the same statement as of the affidavit as in the other writ petition, Your Lordship.
Paragraph 18.
Paragraph 18, Your Lordship, yes.
Yes.
And paragraph 19, Your Lordship.
Yes.
It appears, Your Lordship, that 13,96,000 had been released by the state and 3,12,000 had been refunded by the principal. In this case, Your Lordship, in this case also, Your Lordship, there was also an order of, if Lordship kindly have para 20 of the affidavit, Your Lordship.
Yes.
There was an inspection, Your Lordship. There was an inspection ordered by the Deputy Commissioner, Your Lordship.
Yes.
If Lordship, if I may read, Your Lordship, that in reply to this aberment made at paragraph 26 of the writ petition, state that the Deputy Commissioner West Garwil District on so and so order for an inspection, and as per the report of the inspection committee conducted on 23/6/2017, the principal was drawing double salary. Lordship, kindly see the private respondent from the secondary section and also as assistant lecturer of political science from higher secondary section. The Deputy Commissioner therefore on so and so direct the principal so and so to return the misappropriate amount which have been drawn in the name of so and so, whose teacher, Your Lordship. So there was a withdrawal of double salary by the private respondent, Your Lordship.
Yes.
So it appears, Your Lordship, that there is a misappropriation of the money released by the state authority, Your Lordship. Then Lordship kindly have
Any proceeding drawn?
Lordship, it appears, Your Lordship, that
Was the money refunded?
Lordship, it appears that there was also a request to the local audit, Your Lordship, for auditing, Your Lordship. If Lordship kindly have page 50, addiction 15, that is at page, where is that page 15? Where is that? Lordship, kindly bear with me. This is Lordship, kindly bear because this is a very old case, Lordship. May I skip that part, Your Lordship? I'll come back again, Your Lordship. Then, Lordship, can you have?
Because you see, Mr. Shulai, this will
Lord-
have a bearing
It will have a bearing, Your
as
Lordship.
far as whatever is due to the petitioner, or whether the petitioner was deprived of his right because of this situation.
That is, Lordship.
But anyway, continue. You continue. You said
Lordship,
you'll come to this later.
I'll come to that later, Your Lordship. If then, Lordship, kindly have read petition number 481. 481. Lordship, kindly have page 11, Your Lordship. This is the same relief, Your Lordship. In all these represents, so the same relief, Your Lordship. And then kindly have the affidavit, Your Lordship, filed by the state, Lordship. If Lordship, kindly have para 9.
Para 9.
Para 9, Your Lordship, yes. We see, Your Lordship, that for the month of November 2013 to January 2014, and also for the year
Just a
2016,
moment. You're reading?
Lordship, I'm reading at paragraph 9 at page 3, Your Lordship.
That with regard to allegation made at
For para 5, Your Lordship. Para 5, Your Lordship. The answering submit that the grant aid and all the salary section of the government meant for the salary of assistant lecturer during the month of November 2013 to January 2014, and also for the year 2016, as passed by the Office of the District School Education Officer West Carville Tura, has been already withdrawn by the respondent number 4 and 5. Then, Lordship, kindly have paragraph 18. Same, Your Lordship, that total amount of 13,96,000, and then 3 lakhs.
Yes.
Paragraph 1819, Your Lordship, 13 lakhs 96,000 had been released and drawn by the school principal, and rupees 3 lakhs 12,000 that had been refunded by the said principal to the Office of the District School Education Officer, West Carville District, Tura, Lordship. So for this period, Lordship, whatever salary due to the teacher that had been released by the state, Your Lordship, and drawn by the respondent number 4 and 5, Your Lordship. If the salary has not been paid, Your Lordship, that, in my humble and respectful submission, Your Lordship, that is not the fault of the state, Your Lordship. The school managing committee and the principal is accountable for such lapses on his part, Your Lordship. You got that? Lordship, I'm really handicapped because that annexure in that writ petition 480 is not. Where is the affidavit?
If you have made any averment, then you have to
Lordship,
you have to have corresponding backup for that.
Lordship, if Lordship kindly have come back to writ petition number 480, Your Lordship, 480. If Lordship kindly have a paragraph 20 of the affidavit.
Yes.
Lordship, yes. If Lordship kindly come to page 9, second paragraph, Your Lordship. Further, in order to ascertain the total amount of double salary and excess amount drawn by the Shri I.H. Chaudhary, the Office of the District School Education Officer, through its additional director, have sent a letter to the Director Local Fund Audit Meghalaya, Shillong, to conduct special audit of the Karudwi Higher Secondary School by memo so and so. So it appears, Your Lordship, that there was a request made to the local audit, Your Lordship, for auditing the money, Your Lordship, in the school, Your Lordship. Lordship, that
Where
is
is
the
where is
letter
the
dated.
report? Where is the proceedings?
Lordship, I'm sorry, Your Lordship, that even that letter also is not part of the. Do you have the copy? 420. No, this is additional affidavit. No. 13.3. Lordship kindly have, if Lordship kindly have page 30, Your Lordship.
This is the letter.
Letter, Your Lordship. That is
this is the request letter.
Lordship, yes.
What was the follow-up action on this?
On this, so I have the honor to state that there are so and so, so and so, so and so, so and so, and this includes all in all there are allocation of deduction and irregular payment of salary of the teaching staff, including double drawal of by the principal cum secretary so and as per the list so and so. In this connection, as the detailed information regarding the above allocation, especially the double drawal of salary drawn by the above principal, and to ascertain the above allocation and excess amount drawn by the above mentioned principal, I would like to request you to kindly issue necessary order to conduct a special audit on the account of the above school and submit report urgently to the office of the undersigned of copy. So Lordship, it appears, Your Lordship, that there is a request to conduct a special audit with regard to the salary and other affairs of that particular school, Your Lordship.
See, Mr. Shulai,
Lordship.
that letter was dated 13 March.
13 March 2019, Your Lordship, yes.
Now, you have filed this affidavit on 27 May.
20.
2 months have gone by. You should, by this time, you should have had some.
Lordship,
report.
correct, Your Lordship.
Then that could have been incorporated in your affidavit.
Affidavit, yes. Lordship, yes. Lordship, I may, in the meantime, I may have the.
Just check on that.
I'll have that, Your Lordship. Then, in the meantime, Your Lordship, kindly come to writ petition number 479 of 2018, Your Lordship. Where is that? 479.
Affidavit, बोला।
479, Your Lordship. If Lordship kindly have a page 36.
Page
Page 36, Your Lordship. That is the order and the challenge, Your Lordship.
Yes.
This is the letter issued by the District School Education Officer, Your Lordship, to the President Secretary of the School Managing Committee, Your Lordship. If I may read, Your Lordship.
Yes.
Subject: submission of new proposal for science teacher BSc Royal of Karudubi Higher Secondary School, West Karwil. With reference to the subject cited above, I am to state that Muhammad Ali Akbar, BSc Life Science, was appointed by Shri P.K. Hajong, the former Inspector of School, West Karwil, to abide order so-and-so, while Karudubi Secondary School was placed under the district administration based on the mark sheet of single subject in mathematics with 30 marks in the higher secondary exemption 1999 science stream all course. However, that 30 marks single subject in mathematics, the mark sheet of Muhammad bearing rule number so-and-so, submitted by him as tampered. Lordship, in this case, Your Lordship, there is a certain case of tampering, Your Lordship, and actually issued to Muhammad Hasrat Ali, which was verified by the Assam Higher Secondary Education Council, Bamun Maidan Guwahati. In this connection, Muhammad Ali Akbar, basically, who has no mathematics in the higher secondary exemption science stream, cannot be considered as the science teacher in the Karudubi Higher Secondary School, West Karwil. For the greater interest, I therefore hereby direct the school management committee was to replace him by the BSc Royal as the science teacher to enable the undersigned to submit the proposal for science candidate to the higher to the authority as possible. Then Lordship, if Lordship then have a page 32. This is the letter, Lordship, from the Director of School Education to the District School Education Officer.
Yes.
Here, Your Lordship, there is a stipulation, Your Lordship. So far, this writ petitioner is concerned, Your Lordship. It says, like, with reference to the subject cited above, I am enclosing here with a petition dated so-and-so received from science teacher of Karudubi Secondary School, which is self-explanatory. You are requested to release the salary due to the science teacher of Karu with effects from so-and-so to so-and-so, or the condition that the science teacher Shri Muhammad Ali Akbar complete higher secondary exemption with matter as one of the subject from any recognized board at the earliest. So, Lordship, in this respect, this is a letter from the District School Education Officer. This is also copy marked to the writ petitioner. So, there is nothing on record, Your Lordship, to show that whether he has completed the mathematics subject or not. There is nothing in the writ petition, Your Lordship. Because in that, so far, the payment of salary, Your Lordship, there is a stipulation, Your Lordship. When you will have to, the salary will have to be released provided he pass through the higher secondary exemption with mathematics as one of the subjects.
Mr. Shula, again at page 36, whether any inquiry was made, any findings returned as far as this case of alleged tampering is concerned.
Lordship, then Lordship, kindly have page 37. Page 37, Your Lordship.
Yes.
It has come to the notice of the undersigned that Muhammad Ali Akbar Biasila, who was appointed as science teacher of Karudubi, so-and-so by Shri so-and-so Inspector of School by letter number so-and-so, while the school was placed under the based on the mark sheet bearing roll number so and so of the higher secondary so and so all course in single subject is doubtful. The mark sheet of bearing roll number so and so of the higher secondary school science stream secured 30 mark in mathematics subject to is tampered. One and none other than issued to Muhammad Hasrat Ali as verified by the Assam Higher Secondary Education Council, Bamuni Maidan, Guwahati. Therefore, Muhammad Ali Akbar BSc, having no mathematics subject in so and so, cannot be considered as a science teacher at Karudibi Secondary in the interest of the student community. So it appears, Your Lordship, that he does not have that. And to that effect, Your Lordship, if Lordship kindly have the affidavit filed by this by the district school education officer. If Lordship kindly have if Lordship kindly have, it appears, Your Lordship, there is a a report, Your Lordship. That has been submitted.
Page 3.
Lordship,
page 3.
kindly have Annexure 3 at page 16.
Okay. Yes.
Lordship, it appears, Your Lordship, that there is a finding, there is a inquiry, Your Lordship, conducted by the district school education officer.
Yes.
If Lordship, if I may read, Your Lordship, towards Lordship, kindly have in the bottom, Your Lordship.
Yes.
That is at 3. That Shri Ali Akbar has completed Bachelor degree in Science BSc in 2000 in Division 2 Andhra University. That the complainant in the instant petition dated so and so, Shri Islam Hik, the then head master of Karudubi government has himself appointed Shri Ali Akbar on 29 September 2003 as science teacher by memo number so and so, copy and close. That further Shri P.K. Hajong, the then inspector of school Karo Hills, Tura, on the basis of the recommendation of Shri Islam Chaudhry, the then head master of Karu Government Aided School, complainant of the instant petition, appointed so and so on 14 May 2004 and allowed Shri to enjoy the science. Since then, Shri Ali Akbar, in the capacity of science teacher, working very sincerely under Shri Islam Haq Chaudhry, the complainant of the instant petition, for almost 1.5 decades and consumed the science candidate devoid of any issue. Mentionably, when the undersigned dissolved the school managing committee, has on the ground of wanton embezzlement of public fund meant for salary of this, he became capital. Then such nefarious issues arises. Conclusion: it is observed that Shri Ali Akbar is innocent, and all the allegation leveled against him by Shri Islam Haq Chaudhry, the complainant of the instant petition dated so, are fake, fabricated, and manufactured, having no legs to stand, is a genuine teacher and possesses all the requisite educational qualification to be science teacher. Ali Akbar has hand behind such fake and tempered. It cannot deny that the complainant Shinso may have intentionally, with ultimate motive on his business interest, manipulated and tampered the certificate produced before you. Therefore, copy of having only material subject is not really exists with him, and same has been sent for verification to Assam. Hence, the undersigned, in the light of the above, would like to request you to dispose of the instant petition and to kindly release the sent candidate in aid of Karudvi school teacher. This is for favor of your information and necessary action. Kindly see your lordship here.
Yes.
As I have submitted, your lordship, your lordship.
So this report is in his favor.
It appears, your lordship. It appears in his favor of your lord. At what time? At one time, your lordship, it appears that there is something, your lord, something, your lordship. What I'm praying before your lordship, it appears, your lordship. First, the money has been released by the state, your lordship, to the school management, your lordship, to the principal, your lordship. Then some amount of money had been returned, your lordship. In this case, your lordship, it appears that there is a we do not know, your lordship, whether that is genuine or fake. We do not know, your lordship, because at one time the state said that you should say that it appears that it is a tampered document, and there is an inquiry by the district school education officer, your lordship, that no, this is fake, your lordship. Lordship, to ascertain this factual aspect, if I may pray, your lordship, that inquiry may kindly be constituted, your lordship.
This inquiry has already been constituted.
Lordship,
This is what is your response to the report? Whether you are as the relevant authority,
lordship,
whether they have accepted this report.
Lordship, it appears, your lordship,
and cleared him from all allegations, or whether they have not accepted this report and recommended fresh inquiry. What is your
lordship? What happened in this case, your lordship? It appears, your lordship, it appears that one officer is giving a clean sheet. Another officer, lordship, that is by the name of, he has filed a police case, your lordship.
So
he has filed a police case.
What have the authorities done in that regard?
Lordship, it appears that nothing has been done. Nothing has been done, your lordship. Lordship, kindly see, your lordship. Kindly see, your lordship. This is a school, your lordship. This is a school, your lordship, where suddenly, your lordship, the future of the student, your lordship, are at stake, your lordship.
We are not on that. We understand the implication. We understand the issues involved. But the fact remains that there is certain allegation against the petitioner here.
Lordship, correct.
You, as the concerned authorities, have directed for inquiry. The inquiry officer has filed his report. If you are not satisfied with that, you say that another officer has filed a criminal case, then it is incumbent upon you to verify the facts and come to a conclusion as to whether this requires further inquiry or not. That you have not done. If you have kept silent,
it appears,
means
lordship,
you have acquiescence.
That it appears, lordship, that nothing has been done, your lordship. Nothing has been done, but lordship,
rightly or wrongly, then he has been exonerated.
Lordship, I will, in my humble and respectful submission, your lordship, this factual dispute, your lordship, where certain allegations have been made, your lordship, will not ignore this allegation, your lordship.
Mr. Shula, you cannot at this point of time call upon the court to come to your rescue. The fact remains that it is incumbent upon you to, if you have noticed all these discrepancies, for you to take necessary action, take the matter to its logical conclusion, and finally come to a finding whether he is right or wrong. But that has not been done.
It appears, your lordship, from the affidavit file, your lordship, nothing.
This is your own affidavit.
Nothing has been done, your lordship.
That means you have accepted. You have accepted this report.
It appears, your lordship, nothing has been done, your lordship.
This is also a case for demand of salary.
This is also for lordship. This is
for
also
release of that salary.
Lordship, this is also,
What's the prayer again?
this is also, there is a prayer for a release of salary also, Your Lordship, yes. Denial, Your Lordship, of salary, Your Lordship.
No, there's also, he was also replaced in the meantime.
Lordship,
Page 10, look at the petition.
Lordship, yes. Denial, release of the salary, Your Lordship.
And this his appointment was also cancelled.
It appears, Your Lordship, that has been cancelled, and
And a fresh
then said as it appears, Your Lordship, his appointment has been
see, Mr. Chulai, if you look at the prayer, firstly, it appears prayer 2, his appointment was cancelled.
Your Lordship, yes.
Prayer 1, he was replaced by a new recruitment process. So, then prayer number 3 is for release of the salary.
Salary, Your Lordship.
That can be, that can be sorted out. But what about this? Now, if a new incumbent has been appointed in his place, then third party right have accrued.
Accrued, Your Lordship, yes.
So what do we do with that? Now, in the light of your own admission that the inquiry report has exonerated him, so he should have been reverted back to his own old position. But how can he do that? Because now another person has
been appointed, Your Lordship.
So it's a dilemma for you. I don't know how you'll.
And Lordship,
And you have not, you see, Mr. Sulai, you have not come with any explanation on that, that situation. You have not come with any additional affidavit on what steps have been taken.
it appears, Your Lordship, that nothing has been done. But be that as may, Your Lordship, so far his salary, Your Lordship, so far his salary, if Lordship kindly have page 27 of the affidavit, Your Lordship. Annexion 9, Your Lordship. So far, the salary of 1,98,000, Your Lordship, this has been drawn by the Secretary of the School Management Committee, Your Lordship. That is for the period with effect
Page 20.
27, Your Lordship.
1,98,000.
1,98,000. Lordship, whether this salary had been paid to him also, Lordship, there is whether this money has really gone into the bank account of the petitioner also, Your Lordship, there.
This, the managing committee will have to explain.
That is why, Your Lordship, I'm making a prayer, Your Lordship, if an fact-finding inquiry, Your Lordship, to go into the aspect of all the allegation, Your Lordship, made in the writ petition, Your Lordship, be gone. Why I'm making this prayer, Your Lordship, because, Your Lordship, as I have submitted earlier, Your Lordship, we have released the salary, Your Lordship. We have released the salary.
That's true. You may have released, but we will see what the managing committee says. Now they'll have to reply and see what they have done.
Then, Lordship, if Lordship only have the additional affidavit, Your Lordship, which we have filed showing the status, Your Lordship. Status of the payment of salary, Your Lordship. If Lordship kindly have our affidavit that has been filed in writ petition number 480.
Zero betul. Zero pada order sheet. Pada.
Lordship has got it.
So,
If Lordship kindly have page 9.
this one. Page.
Page 9 of that additional affidavit.
Yes.
Lordship kindly see first. Lordship kindly see the name of the teacher, Your Lordship. They are all together altogether 11 teacher, Your Lordship. Then one is Bakan. Lordship, at serial number 11, Your Lordship, at page 13 has been shown Bakan.
Yes.
Bakan. Lordship, kindly see serial number 1, Islamic Chaudhry.
Yes.
Then Amir Hussain Sarkar, Your Lordship.
Yes.
Then Abu Hanif Chaudhry. Then Sofikul Islam. Sofikul Islam, he is a red petition 471, Your Lordship. Then 5 Shimati Relisa Bekam. Then number 6 Abu Bakar Chaudhry. Then Your Lordship, serial number 7 Sri Sapidur Islam. Then number 8 Mokibur Rehman. Then Your Lordship, number 9 Ariful Islam. Number 10 Asir Rehman. Where are the petitioner? Then Lordship, kindly have Lordship, kindly have page 14, Your Lordship.
Yes.
Page 14, that is for the year 2019, Your Lordship. Lordship, kindly see the name of the teacher, Your Lordship, at serial number 1. These petitions are nowhere in the picture, Your Lordship. They are nowhere in the picture, Your
This
Lordship.
petitioner.
Lordship, yes. Then Lordship kindly have page 17. Page 17, Your Lordship. At column number 11, Your Lordship, shown Bakan, and below, Your Lordship, there is one person by the name of Nur Alam Chowdhury, appointed on 6/12/2019. Then Lordship kindly have page 18 for the year 2020, Your Lordship. These are the same people, Your Lordship. Then Lordship kindly see at the same page 19, Your Lordship, for the year 2021, Your Lordship, the same people, Your Lordship.
What you mean to say is in all these, the name of this
Lordship, yes.
petitioner is
Because
not,
this
so he is
data,
not, so he is not a teacher.
Lordship, yes. These data have been furnished to us by the principal, by the respondent number 4 and 5, Your Lordship. This petitioner, Your Lordship, they are nowhere, Your Lordship, in the picture.
Yes.
Even in 2026, Your Lordship, you have not done paging for this. If Lordship kindly have page 29, Your Lordship. No, not paging.
Yes.
Lordship, this kindly see, Your Lordship, month year 2026. Then Lordship kindly turn to page 30, Your Lordship, January 36.
Okay.
Lordship, there are no more teacher, Your Lordship. They are not there anymore in the list of teacher, Your Lordship.
Exactly. That is, I think that is their grievance. That they were teacher, they've been serving the school. Subsequently, their name have been deleted, or they were terminated. So that is the crux of the matter. You will naturally produce the records where their name has not figured, because in the meantime their name have been deleted from the rolls.
It appears so, Your Lordship,
Whether
because these are the data.
The question that would arise is whether proper procedure was followed, whether it was justified, whether it was according to law. That is what.
That is for
that is
the school managing committee, Your
Yes,
Lordship.
that's for school managing
To
committee.
say so, Your Lordship. But so far release of salary, Your Lordship, if Lordship holds that they are entitled for a payment of salaries, Your Lordship, the affidavit filed by the state, Your Lordship, shows, Your Lordship, that whatever dues payable to the teacher, Lordship, had been released to the school managing committee, Your Lordship. And for that, Your Lordship, the school managing committee will be liable, Your Lordship, for any lapses whatsoever, Your Lordship, in not releasing the salary payable to the teacher, Your Lordship.
So, Mr. Shulai, there are two queries that you have to satisfy this court.
Lordship.
Number one is with regard to that principle, drawing double salary. What was the step taken? Even after that audit report, what was the step taken? And number two is with regard to the other petitioner who have allegedly produced false certificate. What was the step taken and what was the
Lordship, so far that
whether any complaint? Of course, the complaint was sent to you.
So far that teacher, Your Lordship, it appears, Your Lordship, that nothing has been done, Your Lordship. As if the affidavit disclosed that.
So we will accept that. The court will have to accept that he's a genuine teacher with a genuine document, the genuine certificate, and in the meantime, he has been, improperly, I would say, ousted from service. Another person has been appointed in his place. Now, what would be your step in this regard? Because you cannot have two persons in the same place.
Lordship, yes.
The private respondent there is also represented.
We will respond.
Okay, you're appearing for?
Appearing for managing committee and private respondent is Mr.
So you come back with this answer on the next day.
Lordship, yes.
Yes, so Mr.
After that, the AHG completes, we will respond.
Yes.
You have completed your.
Yes, Your Lordship. So far that payment of salary part, Your Lordship, that we have shown in the affidavit, Your Lordship. Yes. Whatever dues
Yes.
that have been released, Your Lordship, if the school managing committee fail to pay, Your Lordship,
Yes.
that will come within the purview of criminal offence, Your Lordship, misappropriation of public money, Your Lordship.
Yes. Misappropriation, misutilization, whatever.
Lordship, yes.
So
Only, Lordship, I reserve my right to respond to the managing committee, Your Lordship.
I'm responding to the writ petitioner. I'm not responding to the government.
So far that part is concerned, Your Lordship.
I will point out, my lord, from the government level, what action they have taken, and what was the final result, at least in the next submission.
None of the recommendation formulated by the government, as of today, that recommendation still stands.
We will show.
They acted.
Once the learned AHG completed all the petitions, my friend will respond to other remaining
Yes.
petitions. Then I will start.
okay.
Let the government respond. The complete.
So you come then, Mr. Shula, you come back with the answer to the query.
Lordship, yes.
1 week.
1 week, Your Lordship, yes. After a week.
After I will respond, then I will proceed.
Mr. Abraham, you are for? Oh, that is for those two. Yes.
Zaruhil is under curfew now, no?
Yes.
May it pleases your lordship. Lordship, 1 week may not be possible, your lordship, because of the current situation in West Karo Hills.
Oh. So, 2 weeks.
Lordship, give me a 2 weeks time, your lordship. If the situation improve, then lordship. If not, lordship, I'll have to renew my prayer for extension of time, your lordship.
Yes, Mr. Abraham.
To complete, then my part is limited, your lordship.
Because item number, the first 2 item number, we are on the ground of technicalities, lordship. Because in the earlier, at the time of submission, I have already made my submission that there is a violation of rules. And that is the admitted position of law.
We have to get serial number.
No, keep me in the list.
5, 6, 7, 8, 9. Yeah? Oh, yeah. 6, 7, 8, 9. You are in 6, 7, 8, 9.
Lordship, from item 5, your lordship.
5, 6, 7, 8, 9.
Lordship, yes.
Mr. Abraham is in
Serial number 3, your lordship.
3 and 4.
All has been conducted by its Kharmi.
These 3 and 4 is identical, lordship.
But why,
Yes.
Mr. Shulai, I think as the
Lordship,
as a AAG,
Lordship, I'll see what is the relief claim in those in the other 2 writ petition, your lordship.
what this court has observed. I think yesterday I made the same comment. As the AG or an officer of the court who is very senior, it would be better if you sort out the roster of cases to be allotted, because there I've noticed. See, like yesterday, I think you recall, there's a common
It is
judgment.
true, your lordship.
3 cases, 3 appeals filed. One
Then
is
separate counsel is separate
and it
counsel
becomes very
is
very
appearing.
inconvenient. One
Lordship,
GA will
it
appear,
should have
the other will
been
not.
one counsel, your lordship.
So that will
to
be
lead.
easy for everyone.
Lordship, that is
Please ensure. And now Mr. Kharmi is not here. What do we do?
on the next day, your lordship.
Please. Ketuka kita heard Mr. Andy Shulai, Learned AG, on behalf of the state respondent. Hearing is not concluded and will continue on the next date fix. The Learned AG has also submitted that he will apprise this court of the steps taken by the government as far as the query made by the court is concerned. Particularly in the case of to 470 or 471.
Give me the list, no, that list. Yeah, mine.
That principal who's drawing double salary.
This is we have all the cases.
In all cases.
In all the cases, because we have made one prayer.
Oh,
We have made one prayer.
That is in writ petition number 479, your lordship.
particularly as regard the allegation made again the is still the principal, Mr. the Chaudhary, made again Mr.
Islam Haq Chaudhary.
I Chaudhary, the principal of the Garu Dubi Higher Secondary School, Hajipur, West Garu Hills, wherein there is a complete allegation that he has been drawing double salary in his capacity as principal of the said school, and also in his capacity as the assistant professor.
With regard to that matter, criminal case is pending before
It's pending, Your Lordship.
the trial court.
Oh,
And court
okay.
DD also pending before this.
Lordship, so far that
Okay. No, but
extended petitions has no connection with it. All these series of petitions has no connection.
you see, it is there in the pleadings.
But we will respond.
But okay. And
But what happened in those cases, the staff teachers approached the TC, and TC comes to the inquiry committee. TC under the rule has no power. He is already the jurisdiction officer. So the inquiry officer appointed by TC returned a finding against the principal. So the principal challenged that part before the committee of the state. That was nullified. And thereafter what happened? Some of the teachers went to Lokata. Sorry, the Ayurveda. And Lokata directed for FIR. FIR was registered against against 3 of them. Now, 3 persons filed a 482 before this court also, still dependency. 2 has been acquitted. There is nothing against those 2 remaining. But with regard to Mr. Chaudhary, the charge has been free.
is that on record in these proceedings? It's there.
no, no, Your Lordship.
In our evidence, we have reflected.
But what? But, anyway, let's see what the government has done in the. You said so. Secondly, as regard the petitioner in petition number 480, that mathematics teacher.
That is, Lordship, kindly. 479, Your Lordship.
Kunum tu as regard the petitioner, can you have to akanika imo? Sasu akanika 479. Katu kada ya baro. Be have check you ni. How no go appear mo as respondent. But he's kantai baro he. He is the respondent in all.
Yes, respondent, and some of the replies are the petitioner in the local.
To respondent mo. Petitioner respondent principal na thai. Kanibde kanibe 479 mo. So I know a separate order to mo. Mr. Hearing will continue. Nata on a query made by this court. As far as the response of the government, query made. Where is your affidavit, Mr. Sulai? That report.
479. In 479, Your Lordship.
Yes, I think you have read that report where he was exonerated.
Lordship, that is in our affidavit, Your Lordship. That at page 16, Your Lordship, annexure 3.
16.
Lordship, yes.
Query made by the school as to the response of the government with regard to the follow-up action of on the inquiry report against inquiry report filed by the District School Education Officer, dated 23/8/2017, which has practically exonerated the petitioner as far as the allegation of his educational certificate being tampered with, to which the learned AG has submitted that the state is not convinced of such report. Therefore, since there's nothing on record as to the follow-up action taken by the state in this regard, the state respondent is to produce relevant documents or communication or order in this regard. On the prayer made by the learned AG to satisfy this court on such query, the matter is adjourned for 3 weeks.
Apply, Your Lordship.
Item number 10. To shift piano. Keren suara. Yes, berapa?
The other note. Our note, our submission.
Petitioner. Yes, sir. So, Mr. Sen, you have completed your.
Yes, sir.
I think Ms. Bhattacharjee also has completed. Have you completed?
After your thing, I might reply on one after your submissions. I might reply.
You have a
Reply to.
you have a separate and distinct stand as regard the collector.
It's one 2 points is there apart from collectors. Just 1 or 2 points.
Then she should say first,
No,
then I
but
reply.
then my appeal is also there. No, after her.
No, your appeal is even. First we deal with this.
So you finish with this, then I'll
Whether
reply.
you. Yes.
In one shot.
Actually, Lordship, I thought that she will reply. Based on her reply, I might reply.
Okay, you have your own. You have to.
Because my
Cross appeal, I am not replying.
I think cross appeal is also listed today.
It's listed today.
So when
That is why I was thinking that after her reply, if she replies on my cross appeals, then by whatever she will reply on my cross appeal, then I'll revert back to it.
Okay.
So that is why I was.
You don't want to reply on this?
No.
On my appeal?
No, nothing as such. Let her reply first. If she reflects anything on my cross appeal,
No, that is a different thing.
yes, that is what I said. What if anything comes out, then I'll reply to that.
Right to rejoinder. Huh? Right of rejoinder.
That is always there. The thing is, you see, first it's like a ping pong ball.
It's not true.
It goes to one side, then the other side, then it goes on and on.
Yes.
Never ending.
Never ends.
So, madam, you start.
Lordship?
You start.
Yeah, I'll start. Lordship, Mr. Sen has already replied and he has culled out a few points for determination, namely the onus of proof, failure to lead evidence on the statement made in the written statement, failure to effectively cross-examine the claimant's witness, and market value of the land, and compensation for damages. Now, Lordship, here the land was acquired, a notification was issued, and the land was acquired. And what happens upon land being acquired? The collector has to make an award.
Yes.
Lordship will find how the collector will have to make an award. He has to follow the provisions of section 15 of the Land Acquisition Act. Section 11 says the collector shall make an award. 11 kahan gaya hai? This book, man, it's so crazy. Section 11 says that on the day so fixed or on any other date where the inquiry has been adjourned, the collector shall proceed to inquire into the objections if any, and any person interested has stated pursuant to a notice given to under section 9 to the measurements made under this section, etc., etc., the collector has to make an award. And how will the collector make an award? It is while making an award, the collector will take into consideration, Lordship, matters to be in determining the amount of compensation. The collector,
You are reading?
section 15 of the LA Act. The collector shall be guided by the provisions contained in section 23 and 24 of the LA Act.
Matters to be considered and neglected.
Yes, matters to be considered and neglected. Yes. This is what the collector is to do for making the award, for determining the amount of compensation, and that is 23 and 24 lays down what are to be taken into consideration. Uh, 24 deals with matters to be neglected in determination of the compensation, and 23 deals with the matters which has to be taken into. These are the matters which he has to take it into account while making the award. So while making the award, there has to be exercise of mind by the collector in determining the award by taking into account the provisions of section 23 and 24. Lordship, this now the collector has given an award. We don't know on what basis. Thereafter, we accept the money under protest. Not being satisfied, we file a reference. Now we file a reference under section 18, and the collector, upon receipt of that, is to make a statement to the reference court under section 19. In section 19, what the collector has to do, the Lordship will look at in making a reference. The collector shall state for the information of the court in writing under his hand the situation and extent of land with particulars and any trees, buildings standing thereon, names of the person, amount awarded for damages and paid or tendered under section 5 and section 17, or either of them, and their amount of compensation awarded under section 11, amount paid or deposited under subsection 3A, objections to be to the amount of compensation and on ground which the amount of compensation was this and the grounds on which the amount of compensation was to be determined. These are the factors which the collector in the statement that must be contained, and the collector must send it to the reference court. Now, Your Honor will look into the reference court, the statement under section 19 and page 85.
Page 85.
84. Page 84. Whereas Sabitri Devra and Ashish Devra for this has accepted the award under protest made by me under section 11 of the Act and has required by the accompanying application which is hereto annexed that the matter be referred to the court. I hereby make a reference to the court of the Special Judicial Officer, Shillong, and the details contained therein are reflected herein below. Name, Lordship, we are not land acquired for construction of Khanaparo Jorabat Highway. That's the road. Notice is dated this. Declaration is dated this. We have no quarrel with them. Situation and extent of the land. They have said that. Name and address of the people found to be interested in the land of each person, Srimati this and this. Award amount, compensation paid under 11 is this and this. Then total is this much. Now this is the statement which he says. Section 19 clearly sets grounds on which the award was made. So these grounds have to be reflected. That I took into consideration the land value from here, market value from there, and I fixed this. I took into account whatever. That those have to be reflected in this statement. It is not. The reference court wholly overlooked this aspect of the matter. Wholly overlooked that these vital facts are missing. And the reference court ought to have sent it back to the collector, get it right, and then refer if need be. Or if you have not done the exercise, do this exercise. No such things was there. And I'll just place a judgment of the Supreme Court in this country. Section 18, because what has to be placed. I said I don't want to place it, but I'll keep that for 1 week. Lordship, this is I'll just say SCC online 1995 Supreme Court 2 is 2 SCC page 168.
Right.
When
note down that here set up this file by so and so.
That's a page paragraph 7. I'll just read out.
Just a moment.
When the collector,
I'll just
give that.
Para 7.
Para 7. When the collector makes a reference to the court, he is adjoined by section 19 to state the grounds on which he had determined the amount of compensation.
Yes.
If compensation, if the objections raised as to the acceptance of the award, of the collector under section 11 by the claimant was as regards the amount of compensation awarded by the land for the land thereof, the collector has to state the grounds on which he had determined the amount of compensation where the objection was raised by the claimant in his application for reference under section 18 was as in adequate compensation allowed by the award under section 11 as required under subsection 2 of section 18 itself. Therefore, the legislative scheme contained in section 12, 18 and 19, which is on one hand entitles the claimant not to accept the award made under section 11 as to the amount of compensation determined as payable for his acquired land, and seeks to refer it to the court for determination of the amount of compensation payable for his land. The other hand, it requires him to make good before the court the objections raised by him as inadequate. Now, for what he has to do, the collector has to give the grounds on which he has determined the award. Then I will raise my awards and say how this is bad. Make good my objections to this before the court. But in the instant case, the collector has done nothing. Absolutely nothing. This is no statement under section 19, and this is the case where the matter has to go back to the collector, ask him to give a proper statement, if at all he has determined the award, and place it before the reference court. This is something which is touches the very root of the proceedings. Now what happens? Then the reference starts. The reference court ignores it, goes ahead with the reference. Evidence are adduced. We have adduced as many as 8 witnesses, and the state has adduced none. All the state has done was file a written statement, not supported by any evidence. No evidence has been laid. Written statement and written submission, which is no good, does not help him any way to prove his case. And even the NHI has also done the same thing. NHI has not raised any objection, anything thus far. They were quite happy merrily sailing with the state. Now, Lordship, we adduce evidence. Our evidence, except for claimant witness number 1 and 2, there are the 2 claimants which were cross-examined, and none of the other witnesses are cross-examined. So their evidence go as uncorroborated, as uncontroverted. They have uncontroverted evidence, and these are the evidence which the court has to court is to accept in the absence of any other evidence on record. Now, a ground has been taken by the state regarding the objection, as if it's not necessary for the appellant to pay give evidence. Although they did not adduce evidence in rebuttal, it does not mean the court is bound to accept the evidence of the appellant. It not cross-examined, which they accept, I think, but they rely on a case where there was, if not effective cross-examination, but cross-examination was there. But in our case, it's zero. It's everywhere. It's cross-examined, declined, and plus there's no evidence from the state side to show this is my evidence. This is the basis on which I have fixed the price. Had you said that, court would have accepted it. But now what is there? Only the evidence of the CW 5, 8 and 7. CW 5 is the revenue officer of the district council. Now he says that he gives a a certificate, but that certificate he does not assess. All he says that what I know is that the market value is 300, sometimes it's also 400 per square feet. But that was not an assessment. That is only, apparently, if your lordship looks at the certificate which has been given by him, which is at page, I'll just give the page. Page 90 something. It's again. Yes, which is at page 35. He writes a letter which he says to Victoria, whoever, who also has a plot of land next to mine, With reference to the subject cited above, I am to inform you the present market value of a land at this Ribhoy district, Nongrum measuring this more or less per schedule, is described below is 300 rupees only per square feet. This is what he says. He has not assessed. He has just said this is what. He is the revenue officer there. Obviously, he knows what is what. Then Lordship will come to the evidence of the Gaubura, the village head. What does he say? He says, I am the village head. He is CW 8. CW 8. His evidence is at page 7. Page 77. He is there, he is the village headman, he is there, he gives his evidence, and at page 77, Lordship will find at 78 that the growing market rate of land at Boridwar GS Road, Ribhoy district, in the year 2006, when the land was acquired by the collector for the 4-lane national highway, was 300 rupees. The 300 rupees per square feet market value of the land and around the area where the land of the claimant is situated at the time of it was not less than 300 rupees per square feet. I know this because I am the headman of the Baridwar village at the time when the land was acquired by the government, and the rate of the land is this, sometimes is even this. So because he is the headman, he knows what is the rate of land, he has given this evidence. Now we have these, as far as the land value is concerned, these are the two pieces of evidence which is there. But when it comes to the Deputy Commissioner, there is no evidence. Even his statement of grounds is not there. What is the evidence on this count? On what?
Have you made any averments or in your pleadings as regard the inadequacy of the section 19 statement?
No, the Lordship, in my pleadings, this is a reference case, Lordship.
But the claim was filed. The claim was filed by you.
Yes, I'll just check up. You have the appeal here. Huh? It's not there. I'll just see. I have sat for the learned court.
That is also a legal issue, so it can be taken up. See, firstly, your objection was on the award, or the assessment by the collector.
Correct, exactly.
Now you say that the collector has not made a proper assessment.
Correct.
Since there was no recourse taken to section 19.
And while making the award, collector did not take recourse to 23 and 24.
Yes. So now, if that is the case, then you have to point out that this is where the fault lies, and what should have been done by the collector. So that in the written statement they would have responded to that, but that has not done.
Lordship, there is no question of written statement here.
No,
in the appeal.
Not in the appeal. I'm talking about the
Lordship.
Before the land acquisition officer.
Before the land acquisition before the reference code, Lordship.
Before the reference code.
Before the reference code, I have objected to that.
Exactly.
I have objected to the amount. Once I object to the amount, it is for the collector to place before the reference code that these are the grounds on which I pass the award. This is under 19, it is his duty, not my duty. Only when he makes those statements, the reference code will take it up. But that was not done.
True. Now you see, at this point of time, you have come before this court to say that section 19 was not fulfilled.
The judgment of the reference court is bad.
In its entirety. So the collector
Yes.
should have,
Should have.
would have done so, but did not do.
You're correct.
That was your case.
Yes.
But whether it has been, is there in your averments, it has to be there. It should be part of the pleadings.
Part of the pleadings before this court.
No, before that.
No reference I could not have made, Lordship. How could I?
But you file your claim.
No, I filed my claim before the collector, and I filed my objection before the collector for making a reference to the reference code
So
under
the
18.
reference
Till
was
that
made.
point, everything is fine.
Exactly. Now when
So now what happens?
If I may be wrong also, because I'm not. Anyway, now once the reference was made
Right.
to the reference court, now the reference court would call upon the parties to file their pleadings. You as a claimant would have filed your claim.
Page,
It should be there.
page 81.
How would you lead evidence then without pleadings?
81 is a reference application. No, that's one. We must have. No, this is before the. This is for making an application. 18. And there has to be one more. Thereafter, Lordship, there's no question of my making a written statement again. It is for them to respond to this. Because I did not make. There was no written argument is here. Lordship, 1 minute. Lordship, I may just check.
The court is inquiring about the reference application.
Reference application is here.
Page 81.
Page 81 reference but after that there's no question of making
That is what the court is inquiring about.
I made the reference application.
Yes.
This is application under section 18.
Just a moment.
Page 81.
Page 36. Just a moment. This is your claim application.
This is my claim petition.
This page
81.
I don't. Just let me check the paperwork and see.
Page 81.
No, not this. I'm talking about. I'll show you the requirement. This is your claim application.
Yes, Lordship, this is my claim petition.
Exactly. That's what I
Yes.
was saying.
Yes.
But you have not incorporated that in your paperwork.
It's there, Manoj. Page 1 of the paper book.
This is a I'll just take it back. This is my claim petition.
Yes, so that's what I was referring to. Yes, it's here. Obviously, this should be the basis.
This is the basis. But that requirement is not for filing my claim. That is for the Deputy Commissioner has to place before the court.
That would be your case.
That would... No, that is
would
for
be
the
your,
court.
that would be your stand. So,
That would be my stand
so
here
we'll-
on appeal,
we'll
but that
see
was
what
for
the-
the...
We'll see what the collector says about it.
Just-
So please continue.
Yes. So after I make my claim petition, the Deputy Commissioner, this is an internal document which Deputy Collector sends to this. This Section 19 application is not marked to me. It's marked to the court.
Yes, yes, obviously.
It's marked to the court. So as per se, I have nothing to do with it. It's only now when the records have come, I have come to know that this Section 9, this is the big fallacy in the Section 19 petition. And the reference court wholly ignores that part. It is for the reference court to take this up. It's a question of law. This is a requirement whether the reference has been made proper. If the reference is not proper, then the court has to send it back right at the beginning, even before registering.
Exactly.
Even before registering, the court ought to have sent it back, which was not done, and the matter continued. So now, had those things been there, there was something before the court to say yes, the land value was determined by taking into account this. As on today, there's nothing on record before the court on what the collector had based his assessment, whether 23-24 was complied with or not. There's nothing on record to say that. Absolutely nothing. No evidence on the part of the collector. Contrary to that, we have placed some evidence before this. We have given the headman's evidence, which is uncontroverted, no cross-examination. We have given the neighbor who found out the land valuation from the revenue authority of the district council. Then again, we have given the district council's revenue authority who says that I was a district council, this is the land value. They want to, the reference court rejected that evidence of the district council, saying that the district council has no right to assess the land value. Correct, Lordship. I have no quarrels with that. District council has no right, but the district council did not assess. He only said this is the land value. Going rate, he's there. He's a revenue officer there. Then, Lordship, the revenue court puts the onus on me to say that I have to prove by way of sale deed to say how the fixation is wrong. Sale deed, etc. The sale deed is the best. But in absence of sale deed, one cannot say that my land will have no value.
See, because the question of comparative value has to be looked into.
Correct. But if there are no sale deeds, what do I do? Or has the deputy collector some sale deed in his before him? He may have, because he's a district collector. That should have been placed. That yes, this is a sale deed. This has not been done, because the collector also has to justify the award. It's not just me. I say your award is wrong, bad, but collector have to place before the court that this is how I assessed. Now, how is it bad? If I say that this is what the collector has not done that exercise. So the reference court ought to have looked into this, and on that basis ought to have compelled the collector to do that exercise, because nothing on record even if I haven't proved my case, but the exercise by the collector has to be done, Lordship. Even for the house,
Exactly.
no exercise. Lordship, there's nothing. And I'll place a number of
So all you see, all that the exercise that you are referring to would fall within the ambit of section 19,
not section 19,
23 and 24.
23 and 24.
Of course,
Because in the reference court has to see whether this exercise has been done. Because the reference court does not sit as an appeal. Reference court could have taken up the matter had there been evidence also from the collector that this is how I fixed. In absence of that, the fixation is absolutely a vacuum, Your Lordship. And when I do not, uncontroverted, when you do not support your written statement, they filed a written statement without evidence to support that. What is the value of the written statement, Lordship? There, which paper? Huh? Paragraph 15. Lordship, paragraph 16, Lordship will find.
Of which case?
Of this case, 2024 Supreme Court Online, page 3851. Para 16. We find that any averment made in a plain or a written statement must be supported by evidence. In absence of there being any evidence, the first appellate court could not have implied that there was already evidence in regard to what was being said as stated in the written statement without recording any evidence in support of the thereof. Then, Lordship, again in 2016-12 SCC, page 288.
Yes. Para
15. Moreover, there's no effective cross-examination made by the made on the plaintiff's witness with the respondent to the factum execution of the said sale deed. PW1 and PW2 have not been cross-examined as to the factum of the execution of the said sale deed. Cross-examination is a matter of substance, not of procedure. Not of a procedure. One is required to put one's own version in cross-examination of the opponent. The effect of non-cross-examination is that the statement of witness has not been disputed. The effect of not cross-examination in the witness has been considered by the court in this. This court repelled the ground on the same was not put either to the witness or suggested before the court below. The party is required to put the version on the witness. If no one is put such question as are put by the court, would presume that the witness account had been accepted and held to be correct. So if you don't cross-examine me, my account is held to be correct. In this case, what has happened, in each and every point, Lordship will find, revenue has not given any evidence. A collector has not given. I have given my evidence. They have not cross-examined. So my evidence has to be accepted as correct. Regarding the land value, which is 300 rupees per square feet, regarding the building, which again was not given to me, was 700 was given to me, 7,900 as against 8,000 which was given to my neighbor. In that count, these two counts, and the loss of business. I had tenants there. Tenants came and said that this is the rent I was paying. It is there on record. The evidence of the tenant is there. in absence, and I have also stated that I had a registered factory there, industry there because it was an industrial unit. I had to shift my industry. That is on record. Those facts are not cross-examined. So those facts remain. In absence of that, Lordship, the reference court is bound to accept mine. And merely to say that you haven't produced a sale deed, that is not enough, Lordship. Sale deed is the best, but in absence of sale deed, what do I do? If there's no sale deed or agreement to sale, I will find from the neighbors, from the people, from the headman who's responsible, what is the sale value. How has the deputy commissioner collector found? I don't know. So those things are not there, and court cannot look into that. Just the written statement court will not look into because it's not supported by evidence. I'm placing these two decisions. Anything else? And this, Lordship, I will just say that that the reference court has failed to do all this because the reference court does not sit as a court of appeal over the collector's award. It has to apply its mind to the facts and come to a positive determination on its own, not merely say that and before the reference court, since it's not a court of appeal, it's a court of original proceedings. Both the parties have to place their evidence, Lordship. I'll just place this judgment, 1988 3 SCC, page 751, that at paragraph 4, what is the power and duties and functions of the reference court? It has been laid down there, and at subparagraph 3 of page 754, it says clearly the court has to treat the reference as an original proceeding before it and determine the market value afresh on the basis of the material produced before it. Now, what is the material which has been produced before it, Lordship? My evidence and nothing by the collector. True and true, it's my evidence, uncontroverted. So if the reference court proceeds on the basis, there is no escaping from the fact that my evidence has to be accepted. Why will they throw it away? For no reason. Because the collector does not want to cross-examine. No suggestion, nothing has been given by the collector. In this situation, Lordship, the reference court erred in not accepting my evidence, erred in fact, right from the beginning, that I will not go to that. And because those grounds are not there, those are not before the reference court. To see that these are the grounds which have been given. Had they given, one could have said, oh, reference court had those grounds and points on which the collector had based his assessment. Those are not before the reference court. Now, what is before the reference court? Only my evidence. And as far as the NHI is concerned, NHI has merely taken the land. All this while NHI is sleeping. No objection, nothing. What are they objecting to? I don't know. If they want the matter to go back to the collector, they are saying that it has to go back to the collector. They cannot take the land without giving me compensation. The compensation will be determined by the collector, thereafter on reference. All throughout they kept quiet, Lordship. Now suddenly they wake up. They have no right whatsoever. Because at this belated stage, they have waived whatever right they had. At this belated stage, they cannot come. Oh, fair enough, give me back my land. I'll give you back your money. Whatever you have given me under, which I have taken under protest. That is all, Lordship.
Dig up the road again.
Dig up the road again? I mean, something like that. So right now at this belated stage, as far as the state government is concerned, they have, collector is concerned, they have not led any evidence before the reference court. So in this view of the matter, now they cannot say, and their evidence not support.
We'll continue.
There's no reply to reply, Lordship.
They'll have to.
There are 3 new judgments which are in place before Lordships. I will distinguish those judgments.
Reply to reply. Where is this?
3
Lordship?
new judgments.
But
Do I not have the right to at least respond to those judgments, my lord? The first judgment is in my favor. They've read out only one singular line. The rest of the paragraph is in my favor.
But I
It's
have
up to
not.
you, lordships.
But there's no question of
urge your
reply to
lordships to give
reply.
me
This is
that
the first time I heard of.
We want law points. Right.
This is the first time I've heard of Lordship. Reply to reply. Lordship can always read the judgments and distinguish. I'll give my written points.
So you will have to reply. So what do we do?
I have not.
I have only 2 points to reply. I just 2 points.
On the cross appeal, Lordship. It has been confined to the cross appeal.
Lordship, I'll just reply to the 2 points.
We'll take it up in the second half then.
Cross appeal? I've not said anything.
Your cross appeal?
Your cross appeal.
Lordship, from the judgments also only, I'll reply on relying on the judgments.
I said we'll.
But these judgments have nothing to
No.
do with the cross appeal. How can they be reply to reply?
Time is up. We'll take up. We'll continue in the second half. Or what do you say?
So I'll need those judgments. We can have it tomorrow, my lord.
Tomorrow we are not coming. But reply to reply
I'll
is
leave it to
some.
you, lord.
No, she has to.
Oh, what?
What you suggested did.
Sanjana suggested it. 31st, Lordship.
31st is a holiday.
No, but we are coming to March. 30th, Lordship.
It is also holiday.
Holiday, what for?
Local holiday.
We can have it on the first then, not first, second.
The second I'll not be here, my lord. We can have it on the 27th. This is 27th. I don't know.
27th, yeah.
Sometime next week.
27th?
Anytime next week.
Don't say anytime.
Anytime next week.
27th. I have to
27th is fine.
come.
27th is fine.
You suggest either 27th or we go to April.
Then April after the 11th, my lord.
After the elections.
After 11th.
After my election. Guwahati election.
Your election is.
I'm not contesting, Lordship.
No, but 9th.
Election Guwahati is on the 9th.
So we'll have it on 13th then. That's a Monday.
She'll not be there, no? 13th is not a holiday.
No.
Just confirm.
You don't have Bihu holiday here.
What do we have?
No, we don't have.
After 13th?
On the I have no problems with that.
13th is fine.
Not 27th, right?
I'm okay with 27th as well.
27th is also alright, Lordship. 27th is also fine.
Yes.
27th.
But the council for the.
This judgment was there right from the beginning. You did not see. Now you
No, this one you not
Reply by
Parasalam.
That was
responded.
always all were there.
NHAI.
I'll take 5 minutes.
Reply to
heard
reply.
on
Then
next
I'll
day.
give another reply.
As agreed to by parties, place this matter for the hearing on 27th.
Obliged.
This is Meghalaya system or Meghalaya High Court.
Item 11.
Lordship, 14 and 15 is also a connected matter.
14, 15. Okay. So 27. 14, 15, 27, no?
May it please your lordship. Your lordship, I'm praying for some accommodation in this matter, your lordship, for today.
That has not been heard.
No, your lordship.
22 heard. On premier petitioner, this is matter up to 2 weeks.
Much obliged.
Item 12.
Lordship, in item number 12, the state respondents were supposed to reply. This is that WAF matter, Lordship, which was heard at length. On 12/3, Lordship. So state respondent Mr. H. Karmi is supposed to
yes.
reply,
May I
Lordship.
please, Your Lordship, like in this matter, our part of hearing is completed.
Lordship, in fact, respondent number 10.
I am
and
for the respondent
petitions-
number 5 to 8 and 11 and 12.
Yes, yes, yes. Noted.
It was for
Where
this-
is the
It is for the state to respond now.
Mr. Shulai? I think
Mr. Karmi is leading,
Mr.
Lordship.
Kharvi is supposed to take up. This is second time he is absent.
Lordship, I'll see into it, Your Lordship. This cannot be done like this, Your Lordship.
Last time he was represented by Mr. Abraham, who has sought for time on his behalf. Now he is also absent.
I'll see into it, Your Lordship.
On pre-meet by state respondent, this is matter of 2 weeks.
Item 13.
May it please your lordship, in this matter, I pray for some time, my lord, because, my lord, I have some difficulty today as I have to go for an appointment, my lord, for doctor appointment in the afternoon.
On pre-meet, this is matter of 3 weeks.
Highly obliged, my lord.
Item number 18.
Where's Mr. Yubin?
He was here in the morning, Your Lordship. No.
Your Lordship, he is ready to do hearing today.
But where is he?
Can I have next week, Your Lordship?
25 matter.
Next week we will have.
1 week time.
Can you have next week, Your Lordship?
Yes, next week, Your Lordship.
2 weeks.
2 weeks. Apply, Your Lordship.
Second call for item number 1.
May it please.